The contemporary legal systems of the world are generally based on one of four basic systems: civil law, common law, statutory law, religious law, are combinations of these. However, the legal system of each country is shaped by its unique history and so incorporates individual variations. Both civil and common law systems can be considered the most widespread in the world. Civil law because it is the most widespread by land mass, and common law because it is employed by the greatest number of people. Common law and equity are systems of law whose sources are the decisions in cases by judges. Alongside every system will have a legislature that passes new laws and statutes. The relationships between statutes and judicial decisions can be complex. In some jurisdictions, such statutes may overrule judicial decisions or codify the topic covered by several contradictory or ambiguous decisions. In some jurisdictions, judicial decisions may decide whether the jurisdiction's constitution allowed a particular statute or statutory provision to be made, or what meaning is contained within the statutory provisions. Statutes were allowed to be made by the government. Common law developed in England, influenced by Anglo-Saxon law and to a much lesser extent by the Norman conquest of England, which introduced legal concepts from Norman law, which, in turn, had its origins in Salic law. Common law was later inherited by the Commonwealth of Nations, and almost every former colony of the British Empire has adopted it. The doctrine of stare decisis, also known as case law or precedent by courts, is the major difference to codified civil law systems. Common law is currently in practice in Ireland, most of the United Kingdom, Australia, New Zealand, Bangladesh, India, Pakistan, South Africa, Canada, Hong Kong, the United States, on a state level, and many other places. In addition to these countries, several others have adapted the common law system into a mixed system. For example, Nigeria operates largely on a common law system, but incorporates religious law. In the European Union, the Court of Justice takes an approach mixing civil law with an attachment to the importance of case law. One of the most fundamental documents to shape common law is the English Magna Carta, which placed limits on the power of the English kings. It served as a kind of medieval Bill of Rights for the aristocracy and the judiciary who developed the law. Civil law, the central source of law that is recognized as authoritative as codifications in a constitution or statute passed by legislature to amend a code, while the concept of codification dates back to the Code of Hammurabi in Babylon, California. 1790 BC. Civil law systems derive from the Roman Empire and, more particularly, the Corpus Juris Civilis issued by the Emperor Justinian, California, AD 529. This was an extensive reform of the law in the Byzantine Empire, bringing it together into codified documents. Civil law was also partly influenced by religious laws such as Canon Law and Islamic law. Civil law today, in theory, is interpreted rather than developed or made by judges. Only legislative enactments are considered legally binding. Scholars of comparative law and economists promoting the legal origins theory usually subdivide civil law into four distinct groups: French civil law in France, the Benelux countries, Italy, Romania, Spain, and former colonies of those countries; German civil law in Germany, Austria, Switzerland, Estonia, Latvia, Bosnia and Herzegovina, Croatia, Kosovo *, Macedonia, Montenegro, Slovenia, Serbia, Greece, Portugal and its former colonies, Turkey, Japan, and the Republic of China. Scandinavian civil law in Denmark, Norway and Sweden. As historically integrated in the Scandinavian cultural sphere, Finland and Iceland also inherited the system. Chinese law, a mixture of civil law and socialist law in use in the People's Republic of China. However, some of these legal systems are often and more correctly said to be of hybrid nature, Napoleonic to Germanistic influence. The Italian Civil Code of 1942 replaced the original one of 1865, introducing Germanistic elements due to the geopolitical alliances of the time. The Italian approach has been imitated by other countries, including the Netherlands, Argentina, Brazil and Portugal. Most of them have innovations introduced by the Italian legislation, including the unification of the civil and commercial codes. Germanistic to Napoleonic influence. The Swiss Civil Code is considered mainly influenced by the German Civil Code and partly influenced by the French Civil Code. The Civil Code of the Republic of Turkey is a slightly modified version of the Swiss Code, adopted in 1926 during Mustafa Kemal Ataturk's presidency as part of the government's progressive reforms and secularization. A comprehensive list of countries that base the legal system on a codified civil law follows: religious and Sharia law. Religious law refers to the notion of a religious system, a document being used as a legal source, though the methodology used varies. For example, the use of Jewish and Halakha for public law has a static and unalterable quality, precluding amendment through legislative acts of government or development through judicial precedent. Christian canon law is more similar to civil law in its use of codes, and Islamic Sharia law is based on legal precedent and reasoning by analogy, and is thus considered similar to common law. The main kinds of religious law are Sharia in Islam, Halakha in Judaism, and canon law in some Christian groups. In some cases these are intended purely as individual moral guidance, whereas in other cases they are intended and may be used as the basis for a country's legal system. The latter was particularly common during the Middle Ages. The Halakha is followed by Orthodox and conservative Jews in both ecclesiastical and civil relations. No country is fully governed by Halakha, but two Jewish people may decide, because of personal belief, to have a dispute heard by a Jewish court, and be bound by its rulings. The Islamic legal system of Sharia and fiqh is the most widely used religious law, and one of the three most common legal systems in the world alongside common law and civil law. It is based on both divine law, derived from the Quran and Sunnah, and the rulings of ulama, who used the methods of ijma, qiyas, ijtihad and urf to derive fatwa. An ulama was required to qualify for an ijazah at a madrasa before they could issue fatwa. During the Islamic Golden Age, classical Islamic law may have had an influence on the development of common law and several civil law institutions. Sharia law governs a number of Islamic countries, including Saudi Arabia and Iran. Though most countries use Sharia law only as a supplement to national law, it can relate to all aspects of civil law, including property rights, contracts, or public law. Pluralistic systems. Civil law and canon law. Canon law is not divine law, properly speaking, because it is not found in Revelation. Instead, it is seen as human law inspired by the Word of God and applying the demands of that revelation to the actual situation of the Church. Canon law regulates the internal ordering of the Catholic Church, the Eastern Orthodox Church and the Anglican Communion. Canon law is amended and adapted by the legislative authority of the Church, such as councils of bishops, single bishops for the respective sees, the Pope for the entire Catholic Church, and the British Parliament for the Church of England. Civil law and common law. Civil law and Sharia law. Common law and Sharia law. Hybrid law. Perceptions. Despite the usefulness of different classifications, every legal system has its own individual identity. Below are groups of legal systems, categorized by the geography. Click the Show buttons on the right for the lists of countries. Some studies show that ethnic minorities are more likely to feel that the legal system within the particular jurisdiction is unfair and unjust. People with mental health issues, particularly young ones, are also likely to have a low opinion of the justice system. By geography,